Assalamualaikum and hi everyone, especially to my beloved lecturer, Ms. Farhana Akwisha, and my fellow friends. My given name is Muhammad Aiman Israel, and it's an honor for my group from Group 4 to deliver a presentation slide short video report on subject Law of Property. The topic that we're going to present is related to law of contract, and the study case that we choose is University versus Ming Chong 1986 to MLJ 148. In this presentation, my group will cover about the summary, parties involved, right duty, issue and problem, element of contract, and the last one is the solution of the case that we have studied. So, that will be the structure of our group presentation.
Case summary. University Malaya versus Lee Min Chong show that the scholarship agreement between Scholarship Authority in bracket University and the scholar in bracket Lee to pursue degree of Master of Business Administration and Accounting in Canada. University of Malaya appointed the dividend to a scholarship offer by the Canadian government under the Colombo Plan to pursue a course of study in Canada for the degree of Master of Business Administration and Accounting. Lee need to serve the university about 5 years. Upon the return, he was to serve the university for a period of not less than 5 years. A breach of them will be rendered Lee liable to pay liquidate damage 5,000 ringgit. Lee served the university for only two years and a half out as stipulate 5 years. The university brought an action against Lee for the said sum of 5,000 ringgit for Lee breach. Many arguments were raised by Lee in his defense. Among them, it was argued that the sum of 5,000 ringgit was a stipulation by way of a penalty and unenforceable law. Even if there was no consideration, the agreement is still valid as a 4 in bracket C, contract in bracket amendment. ACT 1976 provide that the scholarship agreement is not void by absence of consideration. In dealing with defense, the High Court simply referred that a Section 5 in bracket A of the amended ACT and state by the reason of the provisions, the sum of 5,000 ringgit was not a penalty. Thus, the university was entitled to the paid whole 5,000 ringgit. The dividend breached the term and contended that the scholarship agreement was void as it was made without consideration.
Here we go to the next section, which is the parties involved in this case. These cases are involved by two parties, that is the scholar authority and the scholar. The first party is a plaintiff, which University Malaya as the scholar authority, which demand 5,000 from the defendants. The second party is Lee Ming Chong, the scholar who appointed from University Malaya to study in Canada.
This section we go to right and duty for involved party, University Malaya as plaintiff and Lee Min Chong as defendant. Right and duty for plaintiff. The right of the plaintiff, University Malaya, where the sum is specified in the agreement as the amount to be paid in the such violation, notwithstanding anything to the contrary found in the Main Act, shall be entitled the defendant and certainly shall to be jointly and severally liable for payment and the competent authority to be entitled to be paid whether or not the real loss of harm was incurred by the violation, and no deduction shall be made from the sum of the name on account of only any partial duration of service performed by the scholar after completion of his course. Where no amount is stated in the scholarship agreement, the scholar or defendant shall surely be jointly and several liable for payment and shall be entitled to pay by the proper authority the whole amount spent by the appropriate authority under agreement, and the whole such for the amount as it will cost the appropriate authority and another authority designed it to engage person with a qualified and experience similar to those which were to obtain the scholar to perform service required of the scholar on the completion of his course study for the period specified in the scholarship agreement. Section 5 also deals with a case in which, in event of a violation by the scholar, there is an amount named in the agreement as payable. In wording in Section 5 bracket A is plain and does not require any explanation. Pursuant to the section, upon the breach of scholarship agreement, the liability of the scholar is for the whole same name in the agreement, irrespective of whether actual damage was caused, whether the scholar had partially performed in the contract, and other duties found in Section 5 bracket B of the Amendment Act. The section apply where is no sum mentioned in the scholarship agreement as it breached. This is the right, the duty for the defendant, Ming Chong as scholar. The position of the scholar prior and subsequent to the passing of Amendment Act has remained unchanged. The Amendment Act also not provide any remedy to the scholar where there is a breach of the scholarship agreement by the scholarship authority. The liability of the scholarship authority is not dealt with as the Amendment Act is silent on the breach by the scholarship authority. Thus, the scholar has relied on the Contract Act 1950 and common law to obtain remedy against scholarship authority in event of breach. The scholar may put the contract and treat himself as being discharged from the contract by Section 40 Contract Act 1950. The scholar must be first show that scholarship authority has committed a breach of the scholarship agreement. A clear example of a breach of the scholarship agreement is where the scholarship authority failed to refuse or disburse the whole part of the loan sum agreed. Another instance of breach is where the scholarship authority refused to enter the contract of service with a scholar upon completion his study.
This part are to recognize the problem through this case. This issue was answered by Albert Obete. In fact, the university had failed to mitigate its loss. The judge has responded. One Hamza CGI has stated, Lee has not shown how the university could mitigate its loss. Even if there was a loss which could have been mitigated, I don't see how the judgment amount can be reduced such a loss in view of the above provision of Section 5 bracket A of the Amendment Act added. The opinion court held that the obligation of the scholarship authority to minimize its loss was waived from Section 5 and of the Amendment Act. This interpretation is accurate as Section 5A, a simple and unequivalent language, grants the scholarship authority an automatic right to accept the amount named as payable upon the infringement in the scholarship agreement. It was also known as part of the University Malaya vs. Ming Chong, including agreement under the Amending Act. This issue notice was raised case. However, the duty to mitigate loss is placed on the scholarship authority when claiming redress pursuant to Section 5B. The duty to mitigate loss should be extended in a situation where no amount was stated in the scholarship agreement as payable upon infringement. In certain cases, the scholarship authority is entitled to the full amount spent by the scholarship authority pursuant to Section 5 bracket B bracket 1 and the cost incurred by the scholarship authority to employ another person with a similar credential and experience pursuant to Section 5 bracket B bracket 2. Insofar as point 1 of a Section 5 bracket B bracket 1 is concerned, it is claimed that there is no justification to place a duty of mitigation on a scholarship authority. This is because the amount stated under Section 5 bracket B bracket 1 must have been incurred before the violation, namely the entire amount paid by the scholarship authority under the scholarship agreement. The responsibility to mitigate did not exist at all prior to violation. In the case of University of Malaya vs. Ming Chong, the court held that the existence of consideration must be clear, order for the agreement to be legally enforceable.
From this report, the contract elements related to this case are capabilities, contract, scholarship. In capacity, a scholarship agreement means any contract or agreement between the authorities in respect of a person such as student regarding any scholarship, gift, assistance, loan, support or appointment to course of study, the provision of paid or unpaid leave or other facilities whether granted directly by the relevant authority or by any person or any other body or any government outside Malaysia for the purpose of education or study in any form. The University of Malaya is one of the public university that has given scholarships to Lee to continue his study in Canada. Scholarship agreement was validated by S4 of contracts amended notwithstanding any possible lack of consideration. The solution for this case, the Federal Court held that there was consideration as to UN paying fees. Even if there is no consideration, the agreement still applies because S4C of the contract amended at 1976 provides that the scholarship agreement will not be void as there is no consideration. Therefore, Ming has to pay 5,000 to Malaya University as he breached the terms.